Well, I'm very pleased to, can't see you all obviously, but I know you're all out there. You've all given up your Wednesday lunchtime on a nice sunny day to hear me wittering on about costs. So I suppose the first thing is that I'm pleased that you can at least hear me, because I had some guys in to do a bit of fencing work in the garden today, and they've only just finished. Otherwise, you would have heard wave 105, I think, and quite a lot of chainsawing going on. So I'm pleased that you can actually hear me. Ideally, this talk will last about just under half an hour, and then we'll have time for some questions at the end if there are any. If you want to ask a question, there is a Q&A function at the bottom of the screen. Probably easiest if you write your question there, and then I'll go through those at the end, and we can have a discussion about that. Or if it's something you just want to ask me on a one-to-one basis, then maybe if you email me, I'll deal with it over the course of the afternoon, and we can do it that way. Right, so I've got a PowerPoint presentation, so I'm just going to get that up and start sharing the screen. Right, can you all see that? Okay, so we're dealing with costs. I'm just going to whittle through the preliminary bits because you know them all. Obviously, the general rule, Part 28, general rule in financial remedy proceedings, the court won't make an order requiring one party to pay the costs of the other. It's useful sometimes to remind yourself what financial remedy proceedings are. They're basically the hearings that it covers are the first appointment, the FDR, the final hearing. Pretty much anything on an interlocutory basis is not. In those general financial remedy proceedings, so the general rule is no order as to cost, but the court can make a costs order if it is appropriate to do so because of the conduct of a party. So conduct is something we're going to be looking at closely today. Where does the general rule not apply? Quite a lot of stuff, really. Applications for MPS, legal services funding orders, any other kind of interim order, preliminary issues, Part 25 applications about experts, disclosure, also enforcement, penal notices, applications to strike out, set asides, etc. So the list of what it doesn't apply to is considerable and always worth reminding yourself about. And those cases that the general rule doesn't apply to are called the clean sheet category. And so in those cases, the starting point is costs follow the events, just as they would in civil proceedings, but that presumption may be displaced more easily in a family case than in a civil case. And that is the logic of Baker and Rowe or Gojkovic. Now, you'll be familiar with these. These are the criteria the court looks at under the Family Procedure Rules Part 28 when it's thinking about making an offer. These were obviously, these have now been around for more than 10 years, and be there any open offer to settle made by a party is something that we're going to be focusing closely on today. These criteria, A to E, largely mirror what is set out in the CPR. The difference in family proceedings is the financial effect on the parties of any costs order. That doesn't appear in civil proceedings. And so it's always possible to argue in family proceedings that your client can't afford to pay a costs order. If they have to do that, they won't be left with enough to meet their needs. And it's that concept that is going to be eroded, I think, by some of the authorities we're going to look at today. So what kind of offers can we make? Obviously, open offers are disclosable at any stage. They can be shown to the court during a costs argument in which the general rule applies, and of course in clean sheet cases as well. Calderbank and without prejudice offers can't be referred to in general rule cases. Calderbank offers still provide some cost protection in the clean sheet cases, so the MPS, your interim applications, applications about experts disclosure. But I think these days, to be honest, a judge is going to be saying to you, if it's not an open offer, it's not going to carry anything like the protection that the Calderbank offer used to. Without prejudice offers, of course, that's what we have been used to focusing on in the last 10 years or so. Again, increasingly, I mean, they don't offer you any cost protection. They never really have done. Tactically, they've been an important part of our armoury. Question whether they are going to be so in the future. So there's been a gradual kind of judicial group frustration think that originally Calderbank offers, of course, were annoying to judges. They'd spend an entire hearing trying to divvy up the family finances so as to meet everybody's needs. They didn't know what the Calderbank offers said. And then you produce with a flourish your Calderbank offer at the end of the day. And that would upset the needs-based award that the court had made. And so that seemed to be a pointless and rather destructive kind of process. So when the FPR came in 2010, there was this focus on the open offer, and it was only the open offer you could show to the court that was going to give you any cost protection. But the timing of the open offer, if you recall back in the day, was that it only had to be made immediately before the final hearing. So the applicant had to do an open offer 14 days in advance, and the respondent had to respond with their open offer 7 days later. So by the time that obligation kicked in, everybody's costs had run up. And if that open offer, that exchange was going to trigger the settlement discussion, it was really triggering it too late to save anybody's costs. So this Family Procedure Rule Committee Costs Working Group, a name which you'll agree rolls off the tongue, was set up to try and think about how to improve that situation. And they said they were concerned that little positive guidance was given in PD 28A to assist the parties to understand the likely cost consequences of failing to litigate sensibly, failing to engage in sensible negotiations, and/or of making an open proposal which is significantly higher or lower than the award ultimately made by the court. Because of course, that's what we all did, wasn't it? We'd make a realistic proposal which was without prejudice. By the time we were forced to make an open proposal, we went all out for our best case scenario, and that's really been the tactical structure. So the FPR was changed, and that change came in a couple of years ago. We're all familiar with it. When we are thinking about conduct for the purpose of making a costs application, the meaning of conduct was expanded in this paragraph 4.4. The court will take a broad view of conduct for the purpose of this rule, will generally conclude that to refuse openly to negotiate reasonably and responsibly will amount to conduct, in respect of which the court will consider making an order for costs. This includes in a needs case where the applicant litigates unreasonably, resulting in the costs incurred by each party becoming disproportionate to the award made by the court. Where an order for costs is made at an interim stage, the court will not usually allow any resulting liability to be reckoned as a debt in the computation of the asset. So there's sort of 3 points to take away from that, which represent a shift. The first is that in the old days, conduct was always somebody doing something bad, material non-disclosure, not filing your Form E on time, etc. Now, conduct is simply not making an offer, not making an open offer, and that's a very different focus. Secondly, cost orders can be made against people, even if it then means that they can't meet their needs. And that also is going below a baseline that traditionally we think we can't go below that baseline of needs. Well, increasingly, these authorities are saying if somebody's been unreasonable in their cost spend, the court can go below that baseline. And thirdly, if you thought, well, actually, it doesn't really matter if the court makes a cost penalty against my client at an interim basis, because come the final hearing, that just goes on the schedule as a minus, and actually the bottom line of the matrimonial pot isn't altered. It's a neutral position. what this enactment is saying is you can't rely on a judge agreeing with that approach. So that 3 important changes. And then, of course, the 4th important change that came in last summer was that the open offer now has to be made just after the FDR rather than just before the final hearing. And obviously, the point of that is that if the making of open offers is going to trigger the settlement discussion, well, that's going to happen in time for the parties to save the enormous costs that are currently being run up preparing for final hearings. Right, so the new misconduct, if you like, is the failure to make an open offer early. And that goes against, I think, the cultural think of many, many lawyers. I mean, I certainly know when I started out in practice, it was common advice to a client to say, once we've got all the disclosure, once we've got the actuary's report, once we've got the company valuation, once we've really bottomed out every single nook and cranny of that for me, then we can advise you on an offer. I don't think that's good advice anymore. Actually, I don't think it's been good advice for a while, but it's certainly not good advice now. The expectation now from the judiciary is that as soon as you can kind of sit down and do a back of fag packet calculation, you should be able to make an offer. And we'll come on to maybe how you can phrase or structure that offer so as to give you some flexibility. Okay, I'm just going to whittle through some of the recent authorities. This is the first one. It actually predates the legislative changes that we've just been looking at, but it's part of that judicial thinking that led to those changes being made. So WG and HG, a decision of Mr. Justice Francis. Although there was a lot of money in the case, it was all on the husband's side. It was a relatively short marriage, that the wife had health problems. And so she had an income need, and the court found that to meet her income need, she would need a Duxbury fund of 900,000. She hadn't made a reasonable open offer. In fact, she hadn't made any open offer until the 11th hour. And when it did come, it was ludicrously overambitious. She had spent 926,000. And she'd already paid half of that, but half of it remained outstanding to her solicitors. So, of course, she said, well, as well as my housing need and my income need, I've got this need of nearly £500,000 because I have to pay my solicitors off. And of course, you know, the judge accepted, yeah, it's a real debt, it's a commercial debt, the solicitors are entitled to be paid. But the court found that this wife had run up that bill unreasonably and unnecessarily. And so it didn't give her the money to pay it back. Francis J. said, people cannot litigate on the basis that they are bound to be reimbursed for their costs. No one enters litigation simply expecting a blank check. I mean, I paused there because actually I think half of my clients expect exactly that. But anyway, she will have to make the sort of decisions about budget managing that other people have to make day in, day out. So it's a pretty hard message that this lady was left with a situation whereby once she'd paid her solicitors, her Duxbury fund would have been cut in half, and therefore, of course, her income would be cut in half. Now, you might look at the numbers of that, and you might be in front of one of the district judges locally that we are often in front of, and of course, they will say, you know, oh dear, the poor wife in WG and HG reduced to her last, I think, 2.3 million she got overall. It's all very well for the High Court bench to talk about needs, but that isn't actually the kind of case that I'm concerned with. So we go on to this case, MB and EB, which on one side is maybe a more familiar situation. Although the wife was loaded, she was worth 50 million. The husband, he owned the flat that he lived in Brighton, which didn't have very much equity in it, and he had no income. He had about 30 odd grand in savings. He'd spent that on legal fees. The parties' marriage in substance had only lasted for about 4 years, but they hadn't got divorced. So they'd been separated from 2004 until they divorced in 2017 and their finances determined in 2019. It was only ever going to be a needs case, but the husband ran a ridiculously overambitious claim. And I don't know who the solicitors were. I think they're probably certifiable. He ran up £650,000 in costs. This is a guy who had nothing. So they'd taken the £36,000 off him, which was his entire savings. Then they'd made a legal services funding application on his behalf, which was partly successful in that the court ordered the wife to pay his then outstanding bills and something towards the future of £236,000, but it had secured that against his flat. So it wasn't a gift, it was a loan. And of course, by the time he got to the final hearing, he'd run up a further £380,000 bill, which was unpaid. Now, the wife had offered £300,000 early in the claim, open offer. Then she'd increased that halfway through to 336. The husband sought 1.3 million. Cohen said, you know, as wide of the mark as can be imagined. And Mr. Justice Cohen assessed his needs-based claim at 325. So slap bang in the middle of the wife's two open proposals. And that was on a Duxbury calculation. He said, but I need to pay my costs as well. And because she's got all the money and I haven't, on any view, that's a capital need. And my needs have to be met. That is my baseline. And the wife said, well, maybe that would have been true if his costs were reasonable and if he'd pursued his case reasonably, but he hasn't done either of those things. And Mr. Justice Cohen agreed with her and decided that if the case had gone to final hearing, but everybody had behaved reasonably, then the husband's cost bill might have been in about 150,000. I think that's quite a lot of money for what should have been a relatively straightforward case. And in reality, the wife probably would have had to pick up that tab. And it was, as the court described, a pinprick in her resources, which were 50 million odd. So the husband was awarded 325 for his Duxbury and 150 towards what his cost should have been. So 485 as a lump sum. But he already owed the wife 236 and he owed his solicitors 380,000. So he owed over 616,000 and he got 485. So he was put in a negative position. So this is a good example of the court making an order that not only puts somebody below the baseline of their needs, it actually puts them into a negative technical insolvency. So it's a hard message about running up unreasonable costs. RM and TM headline starts with the kind of figures we're probably familiar with. 22-year marriage, parties in their early 50s. Their only liquid asset was the house, equity of about 630. The wife had minority shareholdings in a couple of family businesses, but they were illiquid. So they weren't going to be there to meet needs. She made an early open offer. Let's go 50-50 with whatever that's left. The husband said, no, I need 480. She ran a conduct case, which had no merit, wasted costs, but she dropped it after the FDR. He ran a ridiculous case on all sorts of fronts, made about 13 different applications, lost on most of them, appealed most of them. So by the time they got to a final hearing, they had spent over £600,000 in costs. Some of that was outstanding, 466 was outstanding to their lawyers. They had the other hard debts of 154. So they got 630,000 in liquid capital, 620,000 in debt. No prizes for guessing the results. They got £5,000 each. They both made a cost application, but the wife had been penalised at an earlier preliminary hearing with a £15,000 cost order, which she'd never paid. The court took the view at the end of the day that the husband overall was by far the worst offender when it came to litigation misconduct. And so it made an order against him for 15,000, which of course simply cancelled the earlier cost order out. And the judge said at the end of the judgment, it is scarcely credible that at the end of this litigation, they emerged with about £5,000 each of liquid assets, having incurred nearly 600,000 of costs, but such is the reality. There may be worse examples of disproportionate and ill-judged litigation, but none spring readily to mind. Okay, TT and CDS. If you take away one authority from this little talk, it should be this one, because this is the only Court of Appeal authority. So this is the one you can shove underneath the district judge's nose and say, you can't ignore this. And again, this isn't a case about the impact of open offers. It's a case about what happens where the court assesses somebody's needs at X, but then makes capital provision for them to pay their legal debts or not pay their legal debts, which puts them below their needs assessment. Again, the husband had been the bad boy. The wife had run up costs of 900,000, much of it litigation funding. And when the final hearing was heard by Mr. Justice Cohen, he gave the wife enough capital to pay her debts, including her litigation loans, off. And the consequence of that was that the husband was left with less than he needed, not just what he said he needed, but less than the court had agreed he needed to meet his needs. And so he appealed. And in the leading judgment from the Court of Appeal, which is Lord Justice Moylan, he recites with approval a quote from Morjay in the case called R&B, which says, an order can be made which does not meet needs, because to exclude that option would be to give a license to litigate entirely unreasonably. The court must be entitled to prioritise the needs of the party who has not been guilty of such conduct. So I think these authorities are pushing us into territory where we might feel uncomfortable, because I think generally we work on the basis that the minimum somebody's going to get out of proceedings is their needs met. Whereas these authorities are saying, actually, if your litigation spend is so unreasonable and your litigation conduct is that bad, you may come away with less than your needs. And as we've seen in the MB and EB case, less even than your very, very conservatively assessed needs. OG and AG, you'll all have heard this one. This is the Mostyn one, that the facts are not that relevant. The takeaway soundbite is this bit where he says, it's important that I enunciate this principle loud and clear. If, once the financial landscape is clear, you do not openly negotiate reasonably, you will likely suffer a penalty in costs. This applies whether the case is big or small, or whether it is being decided by reference to needs or sharing. So again, we need to move on and bear in mind and remember that the concept of needs is no longer inviolable. And you cannot simply run up a costs bill and expect it to be paid on top of what the court thinks your reasonable needs are. LM and DM, again, it's just a very short authority that says that that obligation to negotiate openly and reasonably applies just as much in the clean sheet category cases as it does in the general rule cases, and the cost consequences that follow apply to both kinds of cases. AA and AB I've just put in, you can look it up if you need to. It's only the first instance decision of the recorder, but it's a good judgment for containing a summary of the authorities for date. It's also got a good summary about more recent conduct authorities. And again, it's an example of the court making a costs order against somebody who was already in a negative position. So a costs order against somebody who literally had less than zero money. Practical considerations. So when to make the offer? Again, as I say, we need to ditch the idea that it is okay to not make an offer until you feel you have a complete hold on the disclosure and the issues in the case. So you need to understand the broad parameters. And if at the beginning of a case, obviously you're not going to be able to say, for instance, I want an X percentage pension share. And you might not know what a company's worth, and you might not know how much liquidity there is in a company, but that doesn't stop you making a pensions offer, for instance, that says, I want a pension share that's going to provide me with equality of income across all of the pension funds when I'm 60. And with a company, it doesn't stop you making an order that says, I want provision that gives me half the value of the company. If there is liquidity, I want that by way of a lump sum. If there isn't, I want it by way of a Wells and Wells type transfer of shares. So it's fine. It's much better, I think, to make a vague or flexible open offer than to say you can't make any offer at all. Because when you get to that final hearing, 8 months down the line, the judge will still be able to look at your offer that you made a week after the Form E and say, yeah, okay, they weren't able to put numbers on that, but it provided a structure and a principle that was right. And if the other side had engaged with that structure and that principle, then these costs would not have been wasted. So I'm going to penalise the other side in costs. So vague offers, I think, are highly to be recommended. Make them as early as possible. There is always the option of time limiting an order. Personally, I have reservations about that because it can restrict the cost protection ultimately that it provides. I mean, my normal advice on an open offer would be to say it's no orders to costs if you accept this quickly. But if you haven't accepted it within 28 days, then I want my costs paid or at least substantially contributed to. And of course, that's sending a message, because you might not be able to predict what the costs are going to be, but we can always predict that costs are going to go upwards. That early open offer is the best offer you're going to make. And offers after that are going to get more expensive to accept because your legal costs are going to go up and all your debts are going to go up. What is the future of the without prejudice offer? Many of my colleagues say nothing. There's no point making them anymore. You know, I think there are still cases where couples want outcomes that courts are unlikely to do. So as I indicated there, you might often get a couple in their 50s. She really wants the house, which if you went to a final hearing, the court would sell. He really wants to keep his pension. And you know, if you went to a final hearing, the court would share it. But maybe they're both happy, her keeping the house, him keeping the... So that kind of not what the court would do type structured settlement, I think is fine to keep him without prejudice correspondence. But of course, it gives you no cost protection. And it can set the bar for the indication at the FDR. So, you know, you always have to think about that. Calderbank offers, these technically, of course, are still usable, and the case law is still that they give you cost protection in your clean sheet cases, so your MPS application, etc. But my thinking on this is that this whole shift in the way costs are being treated by the judiciary, the procedural changes, the not now the encouragement to openly negotiate, but the penalties if you don't, is because judges don't like dealing with cost applications at the end of a hearing. They don't want to do it. They would much rather take into account the costs expenditure during the substantive hearing. Then they know what they're dealing with. They know the impact of making an award that only allows one party to pay their solicitors and not the other party. They're dealing with matters in the round, and that's more holistic and it's more likely to be fair. Calderbank offers prevent them from doing that because they don't know, obviously, what the Calderbank offer is until after they have made their decision. And I wouldn't mind betting you that even though you might make a really well-pitched Calderbank offer, if you haven't made an open offer, and even if you're successful, for instance, at MPS, you might now get judges saying to you, tough, I'm not going to give you your costs, even though you made a good Calderbank offer, because you didn't make an open offer. That would be following the logic of those two Mostyn cases. So strictly speaking, they still offer you some cost protection, but I think increasingly, with the kind of context of the case law we're dealing with now, judges will use the failure to make an open offer as an excuse not to make a cost order. And so I think Calderbank offers will be of limited use. Boring bits, cost schedules, still need to do those, not just in Form H, but in N260 if you want a costs order. If you're doing bundles where costs are likely to be an issue, whether it's for a costs argument after judgment or as one of the issues within the substantive proceedings, put in all of the Forms H so that you can see how the costs have mushroomed over the lifetime of the proceedings. And also, if you've represented your client or there have been concurrent financial remedy children injunctive proceedings, get information about all of that cost expenditure. Because that's all relevant, especially if there are unpaid or outstanding costs in relation to those other proceedings. Make sure your open offers say what should happen about the costs, i.e. no orders to costs if you accept this offer pronto, but otherwise I want you to pay my costs, and that number will change obviously as time goes on. If you are sensible and you're able to agree consent orders for directions and interlocutory matters that progress the litigation, make sure those consent orders don't say no orders to costs, because then you can't re-argue that one. That means your client pays those costs. If you want all of the costs to be live to be argued about at the end of the day, you need to say costs in the application. And if it's a case where somebody's running conduct and you know they're going to lose, somebody's trying to run a specific issue and you know it's going to go wrong for them, run a separate ledger so that you can make an issue-based costs application with the information behind it that the court can see exactly how much money was wasted. Okay, so I think that's it. Here we are. Hope you can see me again now. Right, so I'm going to go to the Q&A now. Derek, hi Annie. Hi Derek. Right, if you make an open offer before issuing Form A, what is the court's likely position in considering costs? Well, answer is, if it was a well-pitched open offer, you are entitled to claim the whole of your costs from before the issue of Form A, so for the whole of the proceedings. If an open offer is time limited or subsequently withdrawn, does it lose its power? Yes, it does, because costs that may be incurred, it may be that the evidence changed after the offer was withdrawn. Costs are obviously going to continue to be incurred after the offer was withdrawn. But I mean, it's always relevant to say, if you make an open offer for costs, it's withdrawn, but the other side doesn't say to you, actually, if you put that offer back on the table, we would accept it, then there's less argument that the withdrawn offer should lose its cost protection because the other side haven't engaged. So I think it's a grey area, but generally speaking, I would try and find a way not to withdraw an offer, just to make it obvious that certain parts of the offer will have to be renegotiated the later they come to the table to talk about it. What is your advice in terms of open offers? Go in at the highest level or not? Are you held to open offers, or can you possibly do better in a final hearing? Well, that, of course, is the $64 million question. I don't need to tell you guys this is an area of enormous discretion. It's very difficult to predict sometimes what your best case and worst case scenarios are going to be. But the whole point of the changes to the rules and this case law is to change the mindset that your open offer is your best case scenario and then 10%. The whole point is to make your open offer a reasonable offer, so that the other side can say to their client, we're under pressure now because they've made an open offer which is in the ballpark. And if we don't engage with that open offer, you are likely now to get a cost order made against you if you don't accept it or make a reasonable counter proposal. And once you've made an open offer in the ballpark and they make an open offer in the ballpark, most of you guys who are sensible and working together can probably achieve a settlement out of that. We get final hearings out of couples where one party is being completely unreasonable, or both parties are being completely unreasonable, don't we? But usually. So I think the answer to that question is, don't go in at the highest level. Go in at what you think a judge is going to do at the end of the day. And of course, if you don't know what that is, then I'm always available to be instructed. Thank you. Right, that's I think the end of the, oh no, some more here. Should a consent order for an interim application where costs are to be determined later, say costs in the application or costs reserved? Well, costs in the application keeps those costs alive to be argued about. Costs reserved, I would say, is actually only a cost provision that a judge can make. because it's a decision that the court wasn't able to determine the costs at that hearing, because there were other good things going to happen later on down the line that would inform their decision about that. And typically it will be where you've made an interim application maybe for a valuation of something, and the other party is saying, we don't need that valuation because I've told you what that company is worth. Well, if the valuation comes in and exonerates that party, then the court could make the appropriate costs order at that stage. Or if somebody is alleged to have done something wrong, but then actually they're proved not to have done something wrong. So that's where you would do costs reserved. And as I say, I think that's really a judge's costs order. If you are doing a consent order application for directions or whatever, I'd always say costs in the application, because then they get rolled up. Otherwise, you've got to flap about making sure that when you do your Form H in your head, you know what you can extract from that, or from your N260. Okay, well, I think we have taken our 35 minutes. Thank you very much. As I say, if there are other questions that somebody wants to ask me on a one-to-one basis, then please email me. I'm sure you all got my email. It's a.ward@pumpcourtchambers.com, or call the clerks. And thank you very much for listening. And I will probably see most of you again at some stage if we ever get back to going to court. Thank you very much.